So obviously you've got the excitement of a new job and you're going off to work somewhere completely new, but you've found out that you've got some restrictive covenants in your contract of employment. The starting point really is to understand what is in your contract of employment in terms of restrictions, because there are a number of different restrictions that an employer can have in a contract of employment to try to protect their legitimate business interests when an employee is leaving and moving on somewhere new. For example, there are clauses which stop you soliciting customers of theirs or prospective customers of theirs, so we need to know whether that's a non-solicitation clause. There are also clauses that stop you working for someone who competes with your employer, so they are very difficult for employers to enforce, but employers still like to have them because they're trying to protect their business by stopping you going to work for a competitor and taking the confidential information and the contacts you might have to that competitor. The other kind of clause is what we call a non-dealing clause, and that means that even if your customer, who you've built a great relationship with, comes to find you and says, please will you do my work, or will you provide the service that you did before, or will you provide the goods at your new employer, unfortunately you have to say no for the length of the time that the restriction's in place. In terms of the contractual position, if you've entered into a contract with your employer that says that you have those restrictions, then you must assume that you are bound by them. What the law does is say that those clauses aren't enforceable until the employer can show that they've got a legitimate business interest to protect. So what that means is they're in your contract, your employer wants the benefit of them. If they want to enforce the benefit of that, they need to take action against you, which would normally be in the form of an injunction and or a claim for damages for any money that they might lose as a result of you breaching that contract. So it's really important that you proceed with caution and you understand what those restrictions might mean and what could happen if your employer tried to seek the protection of them by enforcing them in a court. Restrictive covenants, as well as being a variety of different types of covenants, may also vary in terms of how long they will last for, and also how big the geographical area is that they cover. For more senior members of staff, you're probably expecting a longer period of restriction and maybe a larger geographical area than you would do for a more junior member of staff. For more senior people, directors and chief executives, that kind of thing, we'd normally expect to see something up to 12 months as a restriction for them, and other members of staff somewhere around 3 to 6 months. Anything beyond 12 months is probably going to be unenforceable. So you've obviously been given the offer of a new job by your new employer and realise you've got these restrictive covenants in your contract. It would be really advisable to make your new employer aware of the fact that they exist, and the reason for that is because, as a matter of law, your employer could be joined in any action against you by your former employer to enforce those restrictions, because they're what we call enticing you to breach your contract. So it's really important that you make your new employer aware, and at least you're getting on a good foot with your employer. The other thing to bear in mind is that the new employer may offer you a contract which says that you're promising that there's nothing preventing you going to work for them in any contract with your current employer. So really important for good employee relationships with your new employer to make them aware, but also because you don't want them to be also at risk of a claim against them if you're in breach of those restrictive covenants.